Pleasant morning to each and everyone. I am REGINA BAÑARES. So after the previous reports under the Title 1 of the Revised Corporation Code, we will now proceed to Title 2, which focuses all about the incorporation and organization of private corporations. Here are the topics that I'm going to discuss. First, we will be able to know the one-person corporation. Second is the difference between Incorporator and the Corporator. Third are the steps in the creation of a corporation. Fourth, number of incorporators. Fifth, qualifications of incorporators. Sixth, partnerships as incorporators. Seventh, domestic corporations or associations as incorporators. And lastly, foreign corporations as incorporators. So, ito po yung nakasaad under Republic Act 11232, Section 10, and para mas madali natin siyang maintindihan, iisa-isahin natin yung definitions na nakalagay. First, any person, partnership, association, or corporation, singly or jointly with others, but not more than 15 in numbers, may organize a corporation for any lawful purpose or purposes. Pag domestic corporation, dapat 2 or more person, but not more than 15, may organize a corporation for any lawful purposes, provided that natural person who are licensed to practice a profession and partnership or associations organized for the purpose of practicing a profession shall not be allowed to organize as a corporation. So, meaning, any groups that is related to the purpose of practicing their profession shall not be allowed unless otherwise provided under special law. So, ano nga ba yung special law? It is the act of legislature which has reference of a particular person, place, interest, and private law which distinct from a general or public law. So, yung special law, siya yung naghihiwalay ng characteristic between the private and the public law. Sabi din sa Section 4, yung corporation created by special law or charter shall be governed by the provision of the special law or charter creating them. So, meaning, kung sino yung nag-create or nagbigay ng pahintulot or nagbigay ng rights na mag-operate yung isang corporation, is sila na yung mag-govern doon. Next, incorporators who are natural person must be of legal age. Syempre, dapat 18 and above. Each incorporator of a stock corporation must own or be a subscriber to at least one share of the capital stock. So, dahil nga stock corporation yung nabanggit, so required talaga na maka-avail sila at least one share of capital stock dahil ito yung nagsisilbing power nila bilang isang shareholder or stockholder. Pero, kung ito ay non-stock, hindi naman ino-authorize na magkaroon sila ng capital stock. And last, a corporation with a single stockholder is considered a one-person corporation as described in Title 13, Chapter 3 of this code. So, ano nga ba yung nakasaad under Title 13, Chapter 3 of this code? Section 116 defined one-person corporation as a corporation with a single stockholder, provided that only a natural person, trust, or an estate may form a one-person corporation. And in the second paragraph, banks and quasi-banks, pre-need, trust, insurance, public and publicly listed companies, and non-chartered government-owned and controlled corporation may not incorporate as one-person corporation, provided further that a natural person who is licensed to exercise a profession may not organize as a one-person corporation for the purpose of exercising such profession except as otherwise provided under special law. So, may mga katanungan tayong sasagutin. First, what is one-person corporation? So, nabanggit kanina, one-person corporation is a corporation with a single stockholder. So, kaya nga tinawag na one-person corporation is dahil isa lang or single lang yung stockholder niya. On May 6, 2019, Security and Exchange Commission in the Philippines started accepting application for registration of OPC. So, dati kasi dapat at least 5 stockholders yung hinihingi in order to comply with the SEC requirements to be registered as a corporation. Pero ngayon, napayagan na kahit isa lang yung stockholder ng isang company is pwede na siya makapag-register. Next, who can register as a OPC in the Philippines? First is natural person, which refers to a living human being with certain rights and responsibilities under law. Second is trust, wherein ito yung katiwala, tagapangasiwa na binigyan ng rights to hold title to property or asset for the benefit of a third party or the beneficiary. And last is the estate, wherein it is a net worth of a person at any point of time, alive or dead. Ito yung kabuoang asset ng isang tao either by legal rights, interest, and entitlements to property of any kind, then less all liabilities at that time. So, note that incorporators who are natural person must be of legal age. So, syempre, dapat nasa tamang edad. Next, who cannot form a one-person corporation? So, makikita ito sa second paragraph ng section 116, wherein OPC in Philippines is not allowed for banks, non-bank financial institution, quasi-banks, pre-need, trust, insurance, public and publicly listed companies, non-chartered government-owned and controlled corporation or yung tinatawag na GOCC, and professional for practice of such profession unless provided under special law. For example, those who are licensed to exercise a profession are not allowed to operate as an OPC, and this includes lawyers, accountants, doctors, and etc. unless provided under special law. Next, can a foreigner registered as a one-person corporation? So the answer is yes. They can also set up OPC, however, they are still subject to Foreign Investment Act negative list, pero dapat yung industry na mapipili nila must allow for foreign ownership. So dahil nalaman na natin yung one-person corporation, meron itong mga advantages compared to corporation. First, yung OPC is beneficial to micro, small, and medium businesses because one-person corporation composed of only one stockholder, while the corporation must have at least 5 stockholders in order to register as corporation. So sometimes there are cases in business na kumukuha lang sila ng stockholders na di pa naman nila gaanong kilala para lang makumpleto yung at least 5 stockholders na hinihingi ng SEC in order to register as a corporation. Pero dahil nga nagkaroon na ng one-person corporation, so mabibigyan na ng karapatan yung ibang company na meron lang isang stockholders. Let us now proceed to the difference between the incorporator and the corporator, but let us know first what is incorporator. So an incorporator is the person in charge of setting up a corporation and registering it with the state. They are responsible for filing the paperwork and signing the articles of incorporation. A business is not fully incorporated and legally registered without an incorporator. Sa madaling salita, yung incorporator is sila mismo yung original na stockholder or member na nakapirma or nakalagay sa articles of incorporation na ipinasa noong nagpa-register sa SEC. In the articles of incorporation, makikita natin dito yung mga main components wherein it is the corporation name, corporation address, corporation type, areas of operation, list of directors, duration of operation, and the name, address, and seal of incorporating body. Next is the corporator, are those who compose a corporation whether as stockholders or as members. In general, a corporation is entitled to enjoy all the benefits and rights which belong to any other members of the corporation as such, but in some corporation where the rights are of a pecuniary nature, Each corporator is entitled to those rights in proportion to his interest. He will therefore be entitled to vote only in proportion to the amount of his stock and be entitled to dividends in the same proportion. So, pag sinabing pecuniary, it is related to money. So, just a short recap, we have two major classes of corporation, namely stock and non-stock corporation. Obviously, pag sinabi nating stock corporation, it is organized for profit to be enjoyed by stockholders. So, each corporator must have a stock and yung stock na yun is equivalent sa power or dividend na meron siya. Siyempre, pag marami kang nabiling stock, mas mataas or mas malaki yung proportion and tinatawag natin silang shareholder or stockholder. On the other hand, in a non-stock corporation is walang ganun kasi ang purpose nila is not for profit and tinatawag lamang silang members. And last, a corporator is not in general liable personally for any act of the corporation unless he has been made so by the charter creating the corporation. So, dito, hindi laging liable si corporator unless it is stipulated or written upon creating the corporation. Now, malalaman na natin yung pinagkaiba ng incorporator and a corporator. First, incorporator are those stockholders or members mentioned in the articles of incorporation as originally forming and composing the corporation and who are signatories thereof. Like what I've said earlier, sila yung original na kasapi ng corporation na nakapirma doon sa mismong articles of incorporation noong nagpa-register sa SEC. And while naman sa corporator are those who compose a corporation whether as stockholders kapag sa stock corporation or as members kapag naman sa non-stock corporation. A signatory of the articles of incorporation. So, Black Law Dictionary defines signatory as a party that signs a document personally or through an agent and thereby becomes a party to an agreement. But it's also used to mean someone who physically signs a contract whether as a party or on behalf of party. Minsan, yung mga signatory is meron ding representative. While sa corporator naman, may or may not be a signatory of the articles of incorporation. So, kaya may or may not be kasi dito pwedeng isa siya sa pumirma, pwede ring hindi. Just take note guys that all incorporators are corporators of a corporation but not all corporators are incorporators. Next, incorporator, it does not cease to be an incorporator upon sale of his share. So, kahit pa ibenta ni incorporator yung share niya sa iba, hindi nito mababago yung katotohanan na part pa rin siya ng corporation kasi nakapirma siya doon sa articles of incorporation. While in corporator, it ceases to be a corporator by sale of his shares in case of stock corporation and in case of non-stock corporation when the corporator ceases to be a member. So, dito naman nagkakaroon ng changes. Once na binenta ni shareholder yung share niya, hindi na siya shareholder. Ganon din sa non-stock is hindi na siya matatawag na member. And last, incorporator must not more than 15 person. The number of incorporator has been cut down from 5 to 2. So, dati 5 kasi yung minimum. And ngayon, 2 na lang. So, the maximum number is still 15. And only a one-person corporation or OPC may have a single stockholder and a sole director. On the other hand, incorporator, there is no restriction as to number except for a closed corporation, wherein yung closed corporation is held by a limited number of shareholders and is not publicly traded. So, sa madaling salita, ito yung mga private corporation. So, proceed na tayo sa steps in the creation of a corporation. First step is the promotion. So, this includes activities done by promoter for the founding and organizing of the business or enterprise of the issuer. So, promotion is the process of bringing together the incorporators or the persons interested in the business of procuring subscription or capital for the corporation. Syempre, kung magfo-form ka ng corporation, kailangan mo na makakasama. Kailangan mo ng shareholders and higit sa lahat, kailangan mo ng capital para ma-incorporate yung corporation mo. Next, in the process of incorporation, first is the verification from the records of the Securities and Exchange Commission that the proposed corporate name is not the same or similar to an existing corporation. So, syempre pag magpaparegister sa SEC, dapat walang katulad yung pangalan ng corporation nyo. Otherwise, hindi siya maipaparegister. Second is drafting and execution of the articles of incorporation by the incorporators. So, the person elected as temporary treasurers should execute an affidavit regarding the share capital subscribed and paid up. The treasurer should also submit a sworn statement of assets and liabilities of the corporation. Next is deposit by the treasurer of the cash paid for the shares subscribed in the bank in the name of the treasurer in trust and to the credit of the corporation. The bank is required to issue a certificate of deposit. Letter D, filing of the articles of incorporation with the SEC together with treasurer's affidavit, statement of financial position, certificate of bank deposit, and certificate as to the name of the corporation. Next is payment of the filing and publication fee. Syempre, magbabayad na. And last, issuance by the SEC of the certificate of incorporators. So, last step is the formal organization and commencement of business transactions. So, formal organization requires the adoption of bylaws and the election of the board of directors and of administrative officers. It also includes the taking of such other steps as are necessary to enable the corporation to transact the legitimate business or accomplish the purpose for which it was created, such as payment of shares. So, next topic is number of incorporators. Under the revised corporation code, 2 or more persons but not more than 15 may organize themselves and form a corporation. Kung matatandaan nyo kanina, nabanggit ko na yung minimum number of incorporators has been cut down from 5 to 2. So, only a one-person corporation may have a single stockholder as well as a sole director. Accordingly, its registration must comply with the corresponding separate guidelines on the establishment of an OPC. So, yung separate guidelines on the establishment is makikita nyo sa link na nasa baba. Next are the qualifications of incorporators. So, each incorporator of a stock corporation must own or be a subscriber to at least one share of the capital. So, na-discuss ko na rin ito kanina na kapag stock corporation is required talaga na magkaroon ka ng kahit isang capital stock para matawag kang stockholder or shareholder. Kasi, kung hindi, sa non-stock ka na lang, wherein nakasaad dito na each incorporator of a non-stock corporation must be a member of the corporation. So, pag non-stock kasi is walang share. And the incorporators may be composed of any combination of natural person, SEC-registered partnership, SEC-registered domestic corporation, or associations, as well as foreign corporation. Incorporators who are natural person must be of legal age and must sign the articles of incorporation or bylaws. Next topic is partnership as incorporators. So, how can a partnership become an incorporator? As stated in Section 3 of SEC MC number 16/2019, incorporators may be composed of SEC-registered partnership. So, bakit nga ba kailangan na SEC-registered partnership is needed? Because a partnership or corporation is obliged to secure a certificate of registration with the SEC to own a license to operate the business. Below are the prerequisites to qualify a partnership to be an incorporator. Nakasaad dito na, in the event that a SEC-recorded partnership is made an incorporator, the application for registration must be accompanied by a partner's affidavit duly executed by all the partners to the effect that they have authorized the partnership to invest in the corporation about to be formed and that they have designated one of the partners to become a signatory to the incorporation documents. So meaning, if this partnership wants to invest in the said corporation about to be formed, then kailangan na consensual or may consensus sa lahat ng partner dahil sila yung magtatalaga ng isang partner na siyang magre-represent sa kanilang lahat, na siya yung magiging isa sa pipirma doon sa signatory in the incorporation documents or yung tinatawag nating articles of incorporation. For example, A, B, and C are the partners in the partnership named ABC Partnership. So they found out that there was a corporation about to be formed, which is the XYZ Corporation. So they need first to have the application for registration kasama yung partner's affidavit na in-execute ng lahat ng partners. And second, kailangan nilang mamili kung sino sa kanila ang magiging signatory sa Articles of Incorporation or Incorporation documents. Pwedeng si A, pwedeng si B, or pwedeng si C. Sa second paragraph naman, sinasabi na if you are SEC-registered partnership but then the status is dissolved or expired with the SEC, then it will not be authorized to become an incorporator. So, hindi ka papayagan kasi syempre, ang hinahanap is yung merong active status or nag-ooperate pa. So, next is the domestic corporation or associations as incorporators. So, how can a domestic corporations or associations become an incorporator? So, as stated in Section 3 of SEC MC number 16, 2019, incorporators may be composed of SEC-registered domestic corporation or association. To qualify a SEC-registered domestic corporation or association to become an incorporator, it should comply with the rules stated in SEC MC number 16, 2019 under Section 5 as follows. In the event that a SEC-registered domestic corporation or association is made an incorporator, its investment in the new corporation must be approved by a majority of the board of directors or trustees and ratified by the stockholders representing at least 2/3 of the members in the case of non-stock corporation at a meeting duly called for the purpose. So here, kinakailangan na bago magkaroon ng investment sa new corporation, dapat it is approved by the majority of the board of directors or trustees. Syempre, pagbobotohan nila yun and it must represent at least 2/3 ng stock corporation. So, next, a director's trustee certificate or a secretary's certificate indicating the necessary approvals as well as the authorized signatory to the incorporation documents shall be executed under oath and submitted by the applicant. So, yung mga certificate is kailangan in-issue either ng director, trustee, secretary, and it needs necessary infos and approval as well as yung inauthorize nila to or be a signatory in the incorporation documents, and it shall be executed under oath for legal process before submitting the application. Next, domestic corporation under delinquent, suspended, revoked, or expired status with the SEC shall not be authorized to become an incorporator. So, in this third paragraph, kagaya lang din kanina, pag mayroong status na delinquent, suspended, revoked, or expired is hindi na siya papayagan na maging isang incorporator dahil paulit-ulit ang hinahanap nila is yung active pa yung status or yung patuloy pa na nag-ooperate. My last topic is all about foreign corporation as incorporators. So, how can a foreign corporation become an incorporator? as stated in Section 3 of SEC MC number 16/2019, incorporators may be composed of foreign corporation. The requirements for the qualification of a foreign corporation are stated under Section 6 as follows. In the event that a foreign corporation is made an incorporator, the application for registration must be accompanied by a copy of document. Example is yung board resolution, director's certificate, or its equivalent, duly authenticated by a Philippine consulate or with an apostille affixed thereto, authorizing the foreign corporation to invest in the corporation, being formed and specifically naming the designated signatory on behalf of the foreign corporation. So, dito, kailangan na yung application for registration is merong kalakip na document, either board resolution, director certificate, na authenticated or proof that it is true and genuine copy of the document. Like in the domestic corporation or association, it also need to name the designated signatory kung sino man ang napili nila on behalf of the foreign corporation. Kailangan din nila ng representative. The continuation of my topic will be reported by the next reporter. And that's all my report for today. Thank you for listening and I hope you learned something. Thank you.